Right, welcome back to Morning Live. And as I told you earlier before we took a break, Mark Omoga is with me in studio, and the discussion is all about inheritance. And the most contentious, and which people do not really understand so well, is what happens when a baby is conceived and the dad actually dies, and is he or she entitled to any inheritance? Mark Omoga, good morning.
Good morning to you.
Well, when you talk about inheritance, it's been a topic that still, as we're talking right now, this morning, a court session might be going somewhere concerning the scorecards and battles on matters inheritance.
Yes.
But still, we have so many contentious clauses that people really don't understand when it comes to inheritance. But maybe when you boil it down and, of course, lock this issue of unborn kids, there's something that really people don't understand. So many cases actually coming in. What's your opinion before you now go to generalize all this thing about inheritance?
Perhaps the issue that has caused perhaps a lot of interest or controversy is the recent issue of the court finding that a baby born 9 months after the death of the supposed father is not entitled to inheritance. This looks like a novel thing in law, but it actually isn't. It is something that has always been there in law. It is not something new. It is not judicial craft or judicial innovation.
Okay.
Section 118 of the Evidence Act it gives a presumption of legitimacy where a child is born within the continuance of a valid marriage.
Okay.
Then there's a presumption that that child is a child of the marriage. Or within 280 days after the dissolution of the marriage. 280 days is about 9 months or so.
Yeah.
But after that, you know, after that, the gestation period for human beings is 9 months.
Yeah.
So if a baby is born after, then the presumption no longer applies.
But when you say life begins at conception, does it apply in the law?
Yes, but 280, look at 280, it's about 9 months. 9 months and a couple of weeks.
Okay.
Yeah, so the gestation period of a normal human being would normally not extend to that much. So if you're saying that with regards to the issue of conception,
Yeah.
well, as long as, you know, conception is, it's different from now, the birth.
Yeah, yeah.
So once a baby is conceived of a man or a woman, once a baby is conceived of a man, it's the child of that man or
Okay.
a woman.
Okay.
Even if the man dies later, then the baby is entitled to inheritance
Yeah.
upon achieving the age of majority. Now, with regards to birth, that's a different thing. Yeah, because now birth, there has to be have been gestation.
Okay.
So if the birth happens after the 9-month period, then by law, it is not something new. It is something that has always been there.
Okay.
Yeah.
Now, something interesting. What if this man knows his days are numbered and
Yes.
writes a will
Yes.
about the unborn baby? What will go on here?
Well, you know, wills usually they fall under a broader concept known as estate planning.
Okay.
Under estate planning, you can decide how your property will be dealt with upon your death. So wills come under there.
Okay.
So with wills, you can gift your property to any number of people. It could be your dependents, or they don't even have to be your dependents. That's the good thing about wills. People even gift their property to pets.
Wow.
Yes.
Okay.
So it depends. But the essential thing is that even if you are gifting your property to whoever you choose to, you should have given some sufficient provision to your dependents, those who are depending on you before you die. So yes, you can gift your property to anyone you want. You can bequeath your property to anyone you want if you're using a will.
Okay.
Yeah.
Now, when you talk about he or she, right now things are changing, and our sisters and mothers can inherit.
Yes.
It was a very, very contentious issue also, whereby women are not allowed to inherit. But the law is very clear right now. Is this being enforced right now? Because now, when you talk about this, sometimes it's easy to be seen on paper, but when it comes to enforcing it, sometimes it's very shaky.
The law has always been clear that there should be no discrimination with regards to inheritance of property.
Okay.
What people do is that they tend to deal with the property of deceased people outside the law, so that when a person dies, then the succession is either tested, that is in the case where there is a will, or intestate. Or it is intestate, the law has clear provisions on how to deal with the property, depending on whether the man was the marriage was monogamous or whether it was polygamous. There are clear provisions. But sometimes people ignore these provisions of the law, which is in itself illegal. It's called intermeddling. You're not supposed to deal with the property of a deceased person outside the confines of the law
Okay.
and outside the authority granted by a court of law.
Okay.
So what people do, they follow some maybe customary rules, customary rules where women are disentitled from the property of their dead relatives. So, and that is entirely illegal.
Okay.
Yeah.
Now, when we talk about polygamists, sometimes it can be very difficult, whereby, at some point, not all men are transparent out here. You might be having a family X in Kajiado, and wife one doesn't know that there's another family in Kajiado. But the family in Kajiado, they understand that indeed there's another family also. So one party is not very conversant with what's going on, no communication. But now in the event of unfortunate death here, sometimes it can be very difficult because maybe the courts will say that indeed the first family or the second family wasn't aware of this whole issue. Now, when it comes to inheritance, what really happens when this family that was in the dark comes in to also claim some possessions from this man?
Yeah, it's quite unfortunate that such things still occur. Things to do with succession. If you're following the proper channels with succession, these things are not supposed to last even more than a year if you're following the normal channels. But it's because of people do not disclose their property, or they do not disclose their family members. And secondly, a lot of people are not aware of some of the ways they can use for estate planning to decide what's going to happen after their death. So when they die, families crop up out of nowhere, things you are not aware about, even some property you are not even aware about. And these are some of the things that you find court cases going on for up to 30, 40 years because of these issues. And it's very unfortunate.
Now, at some point you're told, even the courts, the judges actually, they look at the moral behavior of this deceased man. Because now the moral behavior, for example, let's not go into some nitty-gritties about even the issues of maybe the morality and all everything, but these people who wanasema kutupa mbegu kila pahali. These guys are giving birth aimlessly from kids left, right, center. Sometimes the court really is harsh on such men. But when it's harsh on such men who are dead right now, what occurs to the family present and living? They expect something from them. Do you think maybe these people will still be judged also by the behavior of the deceased?
Okay, perhaps when a judicial officer makes a comment about the moral aptitude of a deceased person, it is not something that is anchored in law. It's just maybe a personal opinion that maybe may be given as part of the judgment. But the law essentially does not regulate morality. So that what is important with succession is that if you look at section 29, the persons who are called dependents, who a deceased person is supposed to have provided for. This is section 29 of the Law of Succession Act. There's the first category of people is the wife, former wives or children of that deceased person. So no matter how someone had, to use your terminology, tupa mbegu, if that child is that person's, then that child becomes a dependent of that deceased person who is supposed to be provided for.
Okay, interesting. So this topic is still on, so we're taking a short break. When we come back, Mr. Mark Omoga will still be expounding more on the issues. Like, for example, now, just before I give you a teaser, before I transition, after his death, the second wife bore 4 other children and 3 daughters and 1 son between 1988 and 2008, and now who she wanted to inherit the deceased estate. But now, what will happen here? Because now she bore other children and the guy is already dead. So coming to you after a short break. All right, welcome back to Morning Live. Yes, I gave you the teaser before we took a break, and I started something that after Man's death, the second wife bore 4 other children, 3 daughters and 1 son between 1988 and 2008, who she wanted to inherit his estate now. But the stepdaughter confronted the court with the question of whether children born posthumously are entitled to inherit her father's estate. But now, the judge actually gave a ruling where the deceased estate be shared in 5 portions among the 4 children he had sired. And of course, in his lifetime, and Mrs. Wangeshi, who was the wife actually.
Yes.
Yes. So,
Yes.
is it about just responsibility, being with familiarity, and you're entitled? Not familiarity, not familiarization with all these things, you're out. What do you think about all this?
I think, first of all, that was a proper interpretation of what the law says with regards to succession, intestate succession. You know, with intestate succession, especially where it was a polygamous marriage, then say one wife has 5 children, the second wife has 3 children. The wife and the children, they are considered as individual units, so that the estate is divided in proportion according to how many units there are between the wife and children. So that was good. So you see, there were 4 children and then a wife, so it was divided into 5 portions, shared equally. So that is good.
Okay. Now, when a single woman goes to get married somewhere else with a kid,
Yes.
you see, this man has accepted both of them. This man now dies. Unfortunately, you're using this word death for it's a discussion that we can avoid. This man dies, and is the kid entitled?
Yes, the law provides for it. Under Section 29, it could be a child, though not his own, but it's a child that he had accepted into his family or as his own. That is 1. And then 2, he had provided for the child during his lifetime. Then the child is entitled to inherit his property.
Okay.
Yeah, that is good.
Okay, interesting. So this boils down to familiarity. If you're not part of his plans when he was alive, you're not getting anything. Is that the case? Because now, for example, the other issue about stepdaughter didn't actually get anything because this guy died before he was able to meet her or maybe take care of her, and then she's out of the equation. Now, do you think it's all about the law kind of just pushes the issue of familiarity, responsibility, and also the fact that now at some point they were together? It's clear. It's clear. No one from outside, from the bracket, can actually benefit.
No. The law provides degrees within which members of the deceased person family or the extended family can claim part of the inheritance. So the first step is usually the immediate family, but then it can extend to stepchildren, the step grandparents, or grandparents or parents, but there's a degree that the law gives, so that the first priority is given to the immediate family members.
When you talk about longevity of these cases in court, sometimes they say you don't need a lawyer. Is it true?
Yeah, especially when these succession matters, they are not contested. Say there's a will, it is a tested succession. The will is not contested in any way. Just apply, you petition the court, letters of probate is granted, probate of the will. Then you come back after 6 months, it is confirmed. After 1 year, you're done with everything. Even when the person did not have a will.
Year.
Yeah, even after the
Why
person.
1 year? This thing is supposed to be maximum of 2 months or something.
No.
Okay.
You can't do it within 6 months, within 2 months. Because first of all, it has to be granted. The letters of administration of or probate of the will has to be granted. And then the law provides for 6 months within which you can take care of a few things here and there, but you cannot dispose of capital assets, things to do with land or such. After 6 months, then you come back to court to ask the court to confirm the grant.
Okay.
Yeah. Now, once the court confirms the grant, now you can dispose of capital assets. But then you have to come back again after 6 months for the court. You give an account.
Okay.
Like the administrators to give an account. Like this estate had this much property.
Yeah.
We dealt with it in this way. This property was given to this person. This property was given to this person. Yeah, and then
Okay.
the matter is closed.
Okay.
But it takes about a year.
Okay. Now, when in a situation whereby there's an unfortunate death of a main character in all this situation, that's a man, and there's no communication, even the kids don't understand. Yes, they know there's a property somewhere. The widow is actually the one taking care of everything. Now, they don't understand what happened, or maybe what the man said in the verge of his maybe taking care of them. They're green. They're very green about now the property to be shared. They don't know anything. Should they ask about all these things?
Well, it's interesting the point that you're raising. Usually people talk about, you can find someone talk about how he wants his property to be dealt with,
Yeah.
and then he dies. The law provides for oral wills. Now, in the case of oral wills, or even written wills,
But let me cut you short. Oral wills, but you work with evidence, you guys.
yes,
But
there are
now-
oral wills, yes, but
Okay.
there have to be at least 2 witnesses.
Okay.
Yeah,
Oh.
who can confirm that, yes, indeed, this person said this.
So you won't even care about if the two witnesses are lying or something. That's it. Case closed. That's like, ukisema sheria ni msumeno. You know, sometimes there's some things like that situation now.
Yes.
Oral, verbal,
Oral will, it
yeah.
still has to be proved
Okay.
in court. Yeah, and the judicial officer is entitled to ask questions of these persons
Okay.
who are coming up as witnesses. Yeah.
Okay, this is very interesting. But in a situation whereby, for example, they're more, for example, boy children than the girl child. For example, in a family setup, we have 6 boys and 1 girl, and
Okay.
the property is not enough for all of them. Do you think the girl can push her agenda here? Because now, at the end of the day, yes, the boys will be given priority socially, because now our culture sometimes can be very unforgiving.
Yeah.
Do you think the girl child will push for her rights here? If it's portion and it's not enough.
The portion is never not enough. Because, look, no matter how small it is, the laws of succession provide for how this property, no matter how small, can be shared between the dependents.
Okay.
Now, women or ladies, they are absolutely entitled to inherit.
Okay.
Yes, they cannot be deprived of inheritance by virtue of being female. That is discrimination that is disallowed by the Constitution, disallowed by the various conventions to which Kenya is a party, which form part of the Kenyan law.
Okay.
So the practice that people usually use to disinherit ladies, it's entitled, it's not condoned by the law. Yeah.
Now, just the other day, Tetu MP James Ndungu, a very good case study, and he's actually locked in a court dispute over a 1.2 billion shillings property located in Kitusuru, Nairobi. But now the problem is he had differed with the brothers about the property. Now, in this situation, the brothers kind of ganged up with developers to start something on the property. But he said that property is not for development. There's still some issues going within the family setup. But now, looking at this issue, he stopped a construction that was about to go down, and he was taken to court. But now the government, or maybe the judicial corridors, saw fit that this guy should be locked because now he's interfering in that process, which they say he was also involved. Do you think now, in a case where there's a breach of agreement, for example, Umoga and I, we agree that something we have to do, you're my brother, this is at X, but nothing happens. Something happens rather, then someone comes to interfere again. Do you think now this is also a breach of kind of agreement in the family setup? Are you maybe responsible in this?
The Law of Succession Act, as opposed to like the other civil procedure, usually in civil procedure, when there's judgment or there's a decree, then there are various ways of executing the judgment. But under the laws of succession, the only recourse is contempt of court. So to the extent that perhaps a court of law has issued a grant has issued letters of administration, then the property should be dealt with according to that order of the court. If it is not, then it amounts to contempt of court order.
Okay.
Now, with regards to the way people usually deal with property that has still not been adjudicated by a court of law, that is what I referred to earlier as intermeddling. That property, before a court issues letters of administration or before a will is probated, it ought not to be dealt with. except to the extent that a court of law issues perhaps some limited grants for dealing with that property. Yeah.
Okay. Now, in this case, he's still managing it, and his brothers have teamed up with some bus. He was managing the estate.
Yes.
Now, there's so many things that actually brought some confusion. He was managing the estate. They reached an agreement, but again, he changed his mind at the 11th hour. In this situation where changing your mind in the 11th hour, and they agreed to your brothers that indeed you have to put something here, then that becomes an issue. What do you think about now this 11th hour kind of knee-jerk reactions whereby you feel like, wow, I don't need this thing to happen anymore. But again, you invested, pumped money to developers to come in, and then boom, it becomes an issue. As the first brother, you know, those things now come in. Now it's with scorecards also, with ego coming in also.
There are things that there's something that we need to distinguish. There is how you deal with the property as adjudicated by a court of law, and according to letters of administration, say it is agreed that it's going to be like. Then there's agreeing as family members that this is how we are going to deal with the property.
Exactly.
Yeah. So you remember, the property of a deceased person ought to be adjudicated according to the dictates of the court of law. Yeah. The letters of administration, what do they say? But if we decide to ignore all that and agree as brothers, our father is dead, this is how we are going to deal with this property. That's still intermeddling. It has to go to court. Yeah.
It's very interesting, and I think inheritance. There's so much going on. Now, let's go back to this issue of unborn babies, because now that's the core discussion you're having today. Now, this unborn baby, yes, the law states clearly that 1, 2, 3 things you're not allowed to inherit anything from your parent because there was no kind of interaction between the two of you. But still, at some point, the widow will at some point divide this to the kid. It happens a lot of time because now the man is deceased, yes, but the widow, because she's the parent, she'll come in and divide. The widow was actually given the property by the man when he left. But now, is there any issue between now this situation whereby even other kids who he's hired will have an issue with the mom now dividing something for this kid who did not see the father?
Okay. First of all, with the advent of technology, IVF, it's possible for conception to happen after the death of this person.
Yes.
So in such a case, obviously, this will still be the child of the deceased person.
Yes.
Yeah. Then there is the issue now that you're raising that this property was left to a widow who was now giving it to someone else who was not entitled. Okay. Now, I assume we are dealing with intestacy because this person could not have featured in the will of the deceased. So now, what happens when, say, someone dies and leaves a child or leaves children with a widow? Then the widow is entitled first to the personal effects on the household property, absolutely, of that person. Those are hers. She's also entitled to the first 10,000 shillings or 20% of whatever remains after you've removed all the things. Then out of that, whatever remains, she's entitled to a life interest in whatever remains. Now, then it's called the net intestate estate. She's supposed to hold it for life so that when she dies, now she leaves it to the children of that deceased person. Yeah.
All right.
But before she dies, she can give it to and then the children, as long as that gift or whatever, when she gives it to them, it takes effect immediately. But if she decides that she's now depriving the children of the deceased person, the dependents of this property, to give it to someone else, then that raises an issue. Someone who was not entitled to benefit, it can raise an issue. And so these dependents can go to court and petition the court to disallow, because that would it disinherits the actual dependence of the deceased person. So it ought to be disallowed.
So my last question for you: are you confident with how the inheritance laws have been framed out in the Republic of Kenya?
Well, with regards to discrimination, there's no gender discrimination in the law. But perhaps it's time to look at the Law of Succession Act with regards to digital assets.
Okay.
Right now, you can find businesses being run on, say, on social media, Instagram. When this person dies, you see, there's goodwill in this online business, and it has monetary value, it has commercial value. So it ought to be inherited. Yeah.
Okay.
So perhaps the law needs to be kept abreast of these changes, and it needs to be. There is a bit of discrimination that also needs to be looked at.
Okay.
For example, there are under Section 32 of the Law of Succession Act, there are certain areas like Kajiado, Wajir, where even Mandera,
Okay.
where the law explicitly says that the rules of intestacy cannot apply.
Okay.
So when the rules of intestacy do not apply, then what applies is the customary law, and customary law usually is discriminatory, discriminative, especially against women. So this is an area that needs to be looked at. And then the other discrimination perhaps is the law expressly says where there is no wife, there are no children of a deceased person, then the property of a deceased person goes first to the father. First to the father, then if he's dead, is when that property can now go to the mother. Perhaps there's some discrimination there.
Okay,
Yeah.
Indeed. All right, thank you so much, Bwana Omuga, for coming today. And it was a very, very tricky topic we've had, but we've actually...